Hello, my dear students. Welcome back to my YouTube channel, and this is your Ate Attorney Anne. And in this video, magdiscuss ta og Rule 110. This is in relation to criminal procedure, okay? So Rule 110, which is all about prosecution of offenses. But for this video, to keep it short, we'll just focus on Section 1 first, okay? So each section or even a bulk of sections, I will discuss in separate videos. So karon focus lang sa sa section 1. Okay, so what does section 1 say? So what is section 1 all about? Section 1 is all about institution of criminal actions. So unsa man ang institution of criminal actions? Ang pasabot ana is unsaon na to pag-start para maka-file ta og criminal case against a person. So na to pag-start. Unsa na to pag-institute. Okay? So criminal actions shall be instituted as follows. So we have first for offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112 by so Section 1 of Rule 112 talks about preliminary investigation. So there are offenses, kung may offenses, mga crimes, no? Kung mga crimes nga kinahanglan og preliminary investigation nga giingon ni Rule 112 Section 1. So if ang kana siya nga crime under sa Section 1, Rule 112, where a preliminary investigation is required, so that is by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. So, kinahanglan na ay preliminary investigation according to Rule 112. But dili tanan, okay? So, later, ato i-discuss unsa man ni nga mga offenses or crimes ang manginahanglan og preliminary investigation. Okay, next. For all other offenses, meaning for those offenses or crimes nga dili na kinahanglan og preliminary investigation. So, how can we institute? According to Section 1, Paragraph B, no, by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts or the complaint with the office of the prosecutor. In Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. The institution of the criminal action shall interrupt the running of prescription of the offense charged unless otherwise provided in special laws. So this will be discussed also in another video pohon when we talk about prescription. So pasabot anang prescription, kung wala pa mo'y idea kung unsa nang prescription of the offense, dili pwede nga katulgan ra nimo imong right ba to file a criminal case. So if naay nahitabo nga criminal act, kinahanglan filean gyud nimo siya, no? Dili pwede nga maghuwat ka og pila ka years diha pa ka mag-decide nga ay filean lang ni nako siya. So for example, gilibak kasi yung silingan no, na inyong silingan kay nag-spread og rumors about you. So na giguba ang imong pangan. So let's say 5 years na ang nilabay unya diha pa ka nag-decide nga mo file sa iya, so prescribed na ang offense, meaning di na ka pwede. So prescription lahi-lahi na siya og number of years, no, nga tagaan ka sa balaod nga in ani nga specific number of years for you to file your criminal case. Otherwise kung nilapas na ana nga years, then dili na ka pwede, meaning prescribed na ang offense, di na ka pwede mo file o case against that person. Okay, so the last paragraph tells us nga once naka-file na ka o criminal case sa against a person, so must stop, ma-pause ang pagdagan sa prescription for that offense. Okay? Okay, so let's focus on the first item here. No? So letter A, coming from section 1 gihapon. So, muna siya, for letter A, kabantay mo sa ato ang mga gibasa ganina, letter A pertains to those offenses nga kinahanglan og preliminary investigation. While in letter B, mao to siya ang mga offenses nga dili na kinahanglan og preliminary investigation. So, balik ta sa letter A. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112. So, unsa man day giingon ni Section 1, kani siya no, at akong gi-highlight og blue. So, man day giingon ni Section 1 of Rule 112. So, ingon didto, except as provided in Section 7 of this rule. A preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. So, ang magic numbers that you need to remember when it comes to preliminary investigation is 4, 2, 1. Okay, 4 years, at least 4 years, 2 months, and 1 day. Ano pasabot? So if naa kay plano nga mag-file o criminal case against a person, huna-hunaon nimo, unsa man ang penalty nga gi-prescribe ani sa balaod para ani nga crime. Okay, kung homicide siya, tanawa dayon, i-search dayon na siya sa Google, no? Or kung naamoy copy of the revised penal code, tanawa dito kung pila ang penalty di ay for homicide. If ang iyahang penalty nakaabot no og at least 4 years, 2 months, and 1 day, that means kinahanglan sa mo undergo og preliminary investigation. Okay? That is according to Section 1 of Rule 112. Okay? Again, kung ang penalty para ana nga crime is at least 4 years, 2 months, and 1 day, kailangan siya og preliminary investigation. But again, naaman sa dinhi makita nimo, except as provided in Section 7 of this rule, meaning under Rule 112, Section 1, nag-refer po siya sa Section 7 sa Rule 112. So except, so meaning di ay, even if kani siya, kaning exception, no, even if nakaabot siya og 4-1 or 4 years, 2 months, and 1 day, di na siya kinahanglan og preliminary investigation. Kanos aman, kung, unsa din siya about ang Section 7, kung naay warrantless arrest. Okay. Ang pinaka-common nga warrantless arrest, for example, is caught in flagrante delicto. Caught in the act jud ka, nakit-an ka sa pulis nga gipatay to nimo imong silingan. Okay? So gi-aresto din kanila without a warrant. So in that case, di ba, kung may kag homicide for example, obviously lapas gyud nag 4 years, 2 months, and 1 day. So supposedly unta, di ba, kaabot unta siya 4-1. Supposedly kailangan unta siya preliminary investigation. Pero kay nadakpan naman siya daan, warrantless arrest, kinasakpan man siya in flagrante delicto man jud siya. So even though nakaabot siya og 4 years, 2 months, and 1 day, di na siya kinahanglan og preliminary investigation. So in lieu of the preliminary investigation, ang kapalitan na, kasi di naman kinahanglan di preliminary investigation kung warrantless arrest, inquest na ang kapalit. So instead of doing preliminary investigation, mag-inquest na. Dili na preliminary investigation. Okay? But that is an exception to the rule nga katong 4-1. Okay? So timan lang kung kaabot ang penalty og 4-1, kinahanglan siya og preliminary investigation. So di ay attorney, kung kinahanglan siya og preliminary investigation, unsaon naman ni namo? Unsa may sunod? Okay. So next, if you have already determined, kung na-determine na ninyo nga nakaabot na siya sa 4-1, that so you already concluded that that offense requires preliminary investigation. So how can we institute a case against that person? By filing a complaint or filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. So di ka pwede mo file diretso sa imong complaint dito sa korte. Okay, kung kaabot siya 4-1, bawal ka mo diretso sa court. Agi sa kasa proper officer. I-file sa nimo ang imuhang complaint with the proper officer para ang kato siya nga officer makakonduct siya sa preliminary investigation. Kaya required man ang preliminary investigation kung kaabot og 4-1, right? So, file sa kag-complaint with the proper officer. Kinsa maning? Okay, before we proceed, mo ni siya itong timan according to the revised penal code, these are our penalties prescribed by law together with their corresponding duration. So, kung makita mo dito, ang kanisya nga crime, ang iyang penalty is presyon mayor. Kung sa man nakadugaya ang presyon mayor, kailangan makahibawo, ana, kay kinahanglan ko din yung ma-determine ang 4-1, no? At least 4 years, 2 months, and 1 day. So, dapat timan-an sa din ninyo. Okay? So, na-terrection perpetua, mo ni siya yung duration. reclusion temporal with this duration, and so on. Prison mayor, prison correctional, arresto mayor, o arresto minor. So, kani mga ginagmay na kayo, no? Wala kaabot og 421. Kani siya, dili mo apply niya ang katong gihisgutan nga rule under letter A. So, timan ilang sa ni siya. So, practice muna. This is just one question, no? Murder. Okay? Murder, does it require preliminary investigation? So, according to the revised penal code, unsa may penalty sa murder? Ang murder is reclusion temporal and its maximum period up to death. Okay? Obviously, may kag-reclusion temporal that is, mo ni ang minimum niya nga penalty no reclusion temporal, ang iyang maximum penalty is death. So, reclusion temporal is 12 years and 1 day to 20 years, right? So, lapas gyud siya 4 to 1. So, does it require preliminary investigation? The answer is yes. Yes, it requires preliminary investigation. So, since hebaw man tanong si murder requires preliminary investigation, unsaan man nato pag-file og murder case against the murderer? So, file the complaint with the proper officer. Kinsa maning okay. So, let's just define very briefly what is preliminary investigation. So, a preliminary, unsa din ang mahitabo sa preliminary investigation? So, a preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and that the respondent is probably guilty thereof and should be held for trial. So, mura siya og initial determination. Kung naaba jud kay sufficient nga enough nga evidence nga murderer jud ni siya, 'di ba? So, imbestigahan sa siya before na siya ma-file ang case ngadto sa court, before na siya tan-aw ni judge didto. Dili sa pwede. Kailangan iagi sa siya og preliminary investigation. Ayo sa iagi sa court, but file the complaint with the proper officer para kaning si proper officer, kung kinsa man gani ni siya, makakonduct siya sa preliminary investigation. So, okay. Kinsa man ning proper officer? Ang pasabot aning proper officer is si prosecutor. So, therefore, asa i-file ang complaint kung kinahanglan og PI, asa i-file ang complaint ngadto sa office of the prosecutor. Kay si prosecutor ang mo-conduct sa preliminary investigation. Okay? In fact, going back here, no. In fact, the prosecuted kung moadto kag office of the prosecutor, daghan man as sila prosecutors didto, no? So ma-assignan jud kung kinsa magani, kung kinsa ang ma-assignan nga prosecutor nga mo conduct sa preliminary investigation, we normally call that prosecutor as the investigating prosecutor. So siya ang mubuhat aning inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief, blah blah blah. Okay? So, muna siya ang rule, okay? If ang offense nga, if ang criminal case imong ganahan i-file falls under 421, katong at least 4 years, 2 months, and 1 day nga manginahanglan og PI. Now, for letter B, it says here, for all other offenses, by filing either the complaint or information directly. So, dito sa letter A, timan i-complaint rato ha, kani, complaint or information directly with the municipal trial courts and municipal circuit trial courts, or the complaint with the office of the prosecutor. So, either a complaint or information, pwede na mo diretso mag-file ana sa MTCs. Okay? Pero kung ganahan mo agi gihapon sa office of the prosecutor, pwede ra gihapon. Pero ang inyong i-file is complaint, daily information. Okay? Kaya nga naman, ang kaning information, only a prosecutor can sign this. Okay? Dili pwede any other person. Pero kung ikaw, for example, ikaw ang victim, complaint ang imong i-file, daily information. So, you have two options if ang offense dili manginahanglan og PI, so you have two options. Ang first is file directly with the MTC or with the court, or moagi gihapon ka sa office of the prosecutor. That's your second na option. Okay? However, na po diri akong gi-violet or purple, no. In Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. So, diba, ingon ko diri sa letter B, if dili na siya kinahanglan og PI, pwede ra ka mo file directly with the court or file with the office of the prosecutor. Duha imong options. Okay? Na kay option to file directly to the court, or ang second option is to file it with the office of the prosecutor. However, if kani siya naa sa jurisdiction sa Manila and other chartered cities, wala kay option. No, ang general rule, dili ka pwede mo diretso sa court. Okay? Kailangan gihapon ka moagi sa office of the prosecutor. Bahala og kana ang offense, dili manginahanglan og PI. Okay? So in Manila and other chartered cities, bahalag wala siya kaabot sa 421, kinahanglan gyapon moagi sa office of the prosecutor. That's the general rule. So general rule for Manila and other chartered cities, file the complaint with the office of the prosecutor even if ang offense dili manginahanglan og PI. Exception if their charter provides otherwise. So each of these chartered cities, they have their own charter, 'di ba? Murag mo na ang set of laws nga specific lang sa ilaha. So sa ilahang charter, makita ninyo, for example, Cebu City, makita ninyo sa Cebu City Charter nga moalaw ba siya o moalaw ba siya nga mo-file ta directly sa MTCs or kinhanglan gihapon moagi sa prosecutor. So that's the exception. But if their charter is silent as to that, follow the general rule that bahalag wala siya kaabot og 421 no bahalag di unta siya kinahanglan og PI, kinahanglan gyapon moagi ka sa office of the prosecutor. But if ang jurisdiction dili Manila and other chartered cities, like for example here in Cebu, unsa man ang dili chartered city or municipality pa lang, let's say Minglanilla, no? So if the jurisdiction is within Minglanilla, and then ang kaso nga imong i-file wala kaabot sa penalty nga 421. So di na kinahanglan og preliminary investigation. So duha imong choice ana. First choice is for you to file a complaint directly with the MTC or file a complaint with the office of the prosecutor. Okay? So that's it for section 1, and I'll be uploading sections 2 and 3 and the subsequent chapters in the next video. And I will be discussing them in the next video. So you can expect the next video to be uploaded a few days after this video. Thank you so much for watching. Bye.